Hello and welcome to another video in our video series, 3 Minutes of California Family Law, brought to you by Family Law San Diego. I'm Bud Kluick, the founding and managing partner of Family Law San Diego. Today's topic is the various agreements that are typically reached in divorce and separation cases. First, we want to emphasize that the judges like this. Courts like it when parties come to agreement. To begin with, it's one less decision that the judge has to make out of the hundreds of decisions they make on a daily basis. Secondly, research shows that when people come to an agreement, they are much more likely to live by that and obey whatever court orders are the results of that agreement. There's buy-in between the participants, and they're much more likely to go along with and live up to what the agreement is. Before we go into some of the details of the various agreements, I want to talk to you about the word stipulation. Stipulation is a formal word for agreement, and it is often written up, signed by both parties, and signed by the judge, in which case it becomes a stipulation and order. And it's part and parcel of what we do at Family Law San Diego. The first agreement that is typically reached in a divorce or legal separation case is an agreement to avoid going to court through some kind of alternative. We call it alternative dispute resolution, or ADR, or consensual dispute resolution, or CDR. They both mean the same thing. Popular types of ADR or CDR are mediation, collaborative divorce, and cooperative divorce. And all of those are offered through Family Law San Diego. The second agreement often is about child custody and visitation. Very often, that agreement is reached at Family Court Services. Family Court Services is the division at the court that handles mediation regarding child custody and visitation. That agreement, if you reach it, will be signed by the judge and will become a court order. A third type of agreement that is frequently reached involves money and living arrangements. There is a guideline for child support in the state of California, but people can agree to deviate from that guideline. They can pay more or less in child support, as long as the children are being provided for with that level of support. In fact, there's part of the agreement has to say the children will be provided for properly. Similarly, the parties can agree to have one person have exclusive use and possession of the house or apartment, or exclusive use and possession of a car. That's particularly helpful when the DMV paperwork is in other partner's name. The fourth type of typical agreements is the ultimate agreement, resulting in a marital settlement agreement or a stipulated judgment. The difference is that marital settlement agreement includes a lot of standard paragraphs that may or may not happen, but you're covered that way. All of the I's are dotted and all of the T's are crossed. The other version is a stipulated judgment, which, although it's an enforceable court judgment, is much more stripped down and just includes the elements of the agreement between the parties. If you have any further questions about agreements in divorce or legal separation cases, please contact us at Family Law San Diego. Our phone number is 619-448-6500, or stated a slightly different way, area 619-448-6500, or visit us on the web at www.familylawsandiego.com. That's www.familylawsandiego.com. Family Law San Diego, one word, no breaks, no dashes, no dots, one word. Thank you for watching another video in our video series, 3 Minutes of California Family Law, brought to you by Family Law San Diego.